Okay. Thank you for your comments here and for bringing the issue to light. I guess just a couple of quick questions and comments from myself. So this legislation is largely stemming from the Thomas decision, and it's my understanding, and I want to confirm that it's your understanding as well, that at the time of the Thomas decision, and actually probably hereafter, there was no other court anywhere in the country that had issued a ruling similar to Thomas or identical.
That's a very good case. That's a very good point, right? I think it is such a bizarre interpretation of the law, saying that your company can be on the hook not only for what you produce, but for any other company that produces a similar product. But there was no court in the whole country, court in the state of Wisconsin, who came up with it. So ridiculous. I mean,
the question that I have had, as others have started to discuss the bill, some have said, I thought we addressed this in Act 2. And I think your testimony kind of speaks to what we have addressed and what we have not addressed in Act 2. So Act 2, in essence, applied to any claims made after enactment of Act 2. Your legislation would look back to those cases filed before the enactment of Act 2.
Right, exactly. I'm not sure the exact effective date. It was something like March 15th of last year, sometime around then. And there were many cases filed in the month before enactment or 2 months before enactment. And we are saying that this will apply to those cases as well.
Okay. And then in making that move to look back, have raised some, I guess, legal questions. I think Senator Erpenbach received a memo that I received, an identical memo too, I think it was identical, memo too, from Legislative Counsel regarding the constitutionality of this proposal. Could you speak to either that memo or your thoughts on the constitutionality, because those questions have been raised?
Right. I think I'm going to distinguish between substantive changes of the law and what I'll call procedural remedies. These people still have the ability to sue manufacturers of this paint. We can discuss whether there's any merits of those cases separately, and this bill doesn't deal with it, and I would say that, quite frankly, it's scandalous. The lawyers are leading people to believe that the lead paint in these houses is responsible for the increases in the levels in their children's blood. But under this bill, we are not retroactively changing their ability to sue the company that produced that paint or the amount of claim that they may have against the company. We are changing a procedural thing whereby they are able to sue all these other companies. And I think if you look in case law over a period of time, things are distinguished there. I'll give you an example of something that was retroactive and a court said was wrong. Early on, when I was in the legislature, I guess I've been here so long, I'd be the only one. I was the only one here. These 5 who was here when this.
Oh, no.
What am I thinking? Right here.
Before you were.
That's right. I'm looking at everybody. This, etc. Okay. Blending into the paint. There was a bill in which we restricted the amount of non-compensatory damages related to medical claims. And in that bill, we reduced the amount of money a plaintiff could receive if they sued a doctor for malpractice. That bill, insofar as we tried to make it retroactive, apply to cases that were called in the pipeline at the time, was struck down. And the reason it was struck down is we were telling those plaintiffs, look, you thought you had a claim of $1 million. We are not going to let you knock that. You were right to $1 million. We're not going to knock that right down to whatever we tried to do that bill, $250,000. Okay, because we're taking something away from them. In this bill, we are not taking away the rights of the plaintiffs to sue for the amount of damages they can get. We are still in this bill saying if you feel your child or your child is damaged $100,000, you can still get the $100,000. And if you feel ABC Paint Company it caused your child $100,000 damage, you can still sue ABC Paint Company for $100,000. What we're doing here is we're changing a procedural thing whereby you can no longer say, we're going to go after, whatever, 30 paint companies or something like that, and say you're all on the hook. So in that regard, I don't consider this a retroactive piece of legislation at all. Now, it is something that we're dealing with procedurally because of, I think, an unethical decision in which retroactively you are telling companies that have been in business forever that you are on the hook, not only if you produce paint, but if any of your competitors produce paint as well. That's a big distinction.
Thank you, Senator. Questions from committee members? Senator Urban.
Okay, apparently the council member was talking about what you're talking about. It doesn't flat out say it's unconstitutional, but it raises significant constitutional concerns.
I would be surprised if somebody doesn't file a court case, but based upon what I see, I think they're going to lose their case.
Okay, and there's also something introduced into the bill draft that it's a response to the legislative council memo. Do you know who submitted this?
I'm sorry.
The name was cut off.